Oh, we wanted me to talk about release. Right, sorry. Okay.
Yeah, the obligations of a police
Yeah.
officer once they've arrested you.
So, if you've been arrested and charged, that doesn't mean that a police officer can automatically take you back to the station, put you on cells, and hold you there for a specific period of time while they fill out their paperwork. That's something we see a lot, is they'll arrest somebody, take them back to cells, and then just say, oh, we needed to fill out paperwork, we needed some time to do that, so we kept this person for 4 hours in cells, waiting while we did that. They can't do that under the criminal code and the charter. So if you have been arrested and charged, you're on the scene of, so in your house, on the street, wherever, and if the officer knows your identity,
Knows where you live.
And there's 3.
Has no reason to believe that you won't show up at court.
Right, and does not think that you're going to continue committing the offense that you're committing or any other offense, then they must release you on what's called a promise to appear. It's a piece of paper. It sets out your charges, it sets out your court date, and it is basically your promise that you will appear in court.
So long as it's a summary conviction offense or a hybrid offense, which translated means not a serious offense.
Right.
Like murder, for example, they're not going to let you go with a piece of paper.
So if in that situation, if they're going to take you back to cells, you should ask why. Why can't I be released right here, right now? Is there anything else?
And you can be released on a promise to appear or an undertaking, and the officer is allowed to, like if they say, well, I have to impose some conditions on you. Say, well, go ahead and do it. Fill out the conditions on the undertaking. They can do that. They have the power to do it. See, arrest and detention, taking you to the station, that's a very, very serious infringement on your civil liberties, right? It's a scary, scary thing to be cuffed, put in the back of a cop car, and taken to jail and put in a cell, and maybe not alone in that cell. It's very scary. And so our law makes it very clear that police officers cannot do that unless they meet certain criteria. I mean, this all makes sense, right? If you don't have to arrest a person for those reasons that Kate articulated, then they must release you at the scene. They got the paperwork in their car. You know, you say, well, the paperwork's in your car, so please go fill it out. You know, and then you'll get an appearance notice. You may get an undertaking that you have to sign that says, for example, you know, in case of a, well, I don't know, you're at a bar, you get in a fight, you're charged with assault, so it says you won't go back to the bar. Or cops like to put no drinking, no alcohol, which is, but you can get these things changed later. But you know, if they give you an opportunity to be released, just go with the conditions, sign the form. Don't refuse to sign the form, because you're going to be able to get that easily changed when you appear in court. And then when you get to the police station, then the officer in charge there has the power to grant release on the basis of a recognizance of up to $500 no cash deposit. So that officer in charge has more authority. And so the citizens should be aware of these things, keep on asking, well, why aren't you releasing me on paper with undertakings instead of taking me to a JP? You know, the funniest one is, not that funny for my client, but I was representing somebody who got charged with assaulting a police officer. And so I was cross-examining the police officer who had my client taken to jail and then had to see a justice of the peace. And I said, all right, well, this is a summary conviction offense, assault police officer. You know my client's name, you know the address, no criminal record. Did you have any reason to think that my client wouldn't show up in court? No. And so show the officer section 495 of the criminal code. Well, then why did you arrest her and not release my client right at the scene of her arrest, which was right outside of a bar on White Avenue? Well, it's our policy if you're charged with assault, police officer, that you're taken into custody. Yeah, that's not a very good explanation, right? That there's differential treatment like that. But this is something that is, you know, I don't know if the person is complaining about it to the police officer about being taken back to the police station. I don't know if it's going to do any good, but it will do some good if the judge thinks that happened, and it also might make the officer think, wait a minute, because a lot of them, I think a lot of this is out of ignorance by the police, frankly. They don't realize that. And the Edmonton Police Service is rather notorious for that. I just was at a meeting yesterday, and one of our members, the criminal lawyers, was saying, Calgary, they release people all the time. And the Edmonton Police Service doesn't, and it's like clogging up the system, right? Jail cells are over full, remand center over full, that sort of thing. So, and all these things that we're telling you about, make sure.
It says, hey, can I look in your bag? I mean, you don't have to give them your bag, and you should verbally object to giving the officer your bag. But again, if you feel threatened, you feel like you have to, my advice would be to give them the bag and just verbally object, because you don't want to be assaulted or have force used on you. Now,
So what in that case constitutes reasonable probable grounds to search a bag?
if you're just walking down the street, they're, well, first of all, I don't know what is in the mind of the officer, but if you're not doing anything other than walking down the street, they should not have grounds to do that. But there might be officers that do stop you and just say, hey, can I search in your bag? They can ask you, you can consent. You should never consent to that. If you feel like they're going to force you, just hand it over and verbally object to it. Then you can deal with that later, either via a complaint or if you're charged in your defense. So, never consent, always object. So, if you are detained or arrested and the officer wants to search your bag, ask him why he wants to do that, and ask to call a lawyer. And as we've already covered, if you're detained or arrested, you do have a right to call a lawyer immediately. And if you do get on the line with the lawyer, you can ask the lawyer, should I be agreeing to this? What should I do? And the lawyer can help you at that point. The officer, and I've seen this happen, even if somebody asserts their right to counsel, the officer might just search the car, the bag anyways. And so that's a problem, obviously. You can't fix it now. That's something you deal with later. But again, always verbally object. And when you're objecting, if you have the wherewithal of that in that moment, because it is scary to say, I object, and can you please note in your notebook that I'm objecting? They probably won't, but if they do, that's great. You can use that in your defense later. And if they don't, then you can tell your lawyer, hey, I objected. I told them to write it in their notebook, and they didn't. And that can give rise to things like negligence, obstruction, things like that. So frisk searches. Now, if you're under arrest, officers, in almost every situation, there are some exceptions. They're entitled to frisk search you. So frisk search is a pat down where the officers just can touch you outside of your clothing to see if you have any weapons or evidence. And frisk searches can go too far. So if you're being frisked and the officer lifts up your shirt or looks in your waistband of your pants, arguably that frisk search has now turned into a strip search. So just be aware of what exactly the officer is doing when they search you, where their hands are, and if you feel like, hey, this is going too far, you need to, again, verbally object, but do not resist. That's very important. Don't resist them, and always verbally object. Do you have anything to add to that?
So, well, how do you, that last question there, how do you know if
How do you
there's-
know?
Yeah.
Well, if the officer is looking inside of your clothing, so like I said, if they're looking at your waistband, lifting up your shirt, I can tell you right now, that's too far. Brisk searches don't cover that. That, I would argue, that's a strip search. If they're going in your pockets, now you said that they can do that, right?
No, you did.
No, you did. I said no. You said yes, so I'm not sure about that.
On a brisk search, so they do the pat down. Let's say that they feel something that feels like a knife. Well, yeah, they can go in the pocket. But if they don't have any basis to think on the pat down, is there something, like, for example, something that feels like a baggie and it's got some, powder or something in it, right? I don't think, they can't do that. They can't go inside the pocket for that because they don't really know what it is, and it certainly isn't a weapon. So they're allowed to search you for officer safety reasons, they call it. This is like, and whenever a bad cop does something and they ask him why, they always say officer safety. But, so they're allowed to protect themselves. But if they don't have reason to believe that inside your clothing there's something that could be a weapon, then they can't go looking for it.
But then again, they can ask you, like they can say, you can see that they're gonna look in your pocket. So then they say, turn your pockets out.
Empty your pockets,
So
yeah.
then you still have to, but you can verbally say, right, I object, right?
Yeah,
Yeah,
exactly.
okay, yeah.
You can say, well, why?
Yeah,
Why do I have to empty my pockets? You don't have the right to do that.
Yeah.
See if the cop will answer you, because
Yeah.
I'm telling you to. All right, well, I'm doing it, but I'm objecting, Yeah.
Thing that I could think of that might differ is if you were a minor, you also have the right to speak to your parent or guardian in addition to a lawyer.
I know, Renee, you wanted this area covered, right? Is there something else that?
What I've been hearing in the school from the experience that I've had with some students, particularly from the Black community, is their phones are getting confiscated by the school.
And do they have to give up the password?
They did. Yeah.
So the cop said, give me your password, and they did. Wow. And who are they targeting?
The students there were 3 students in one school. They were all Black students. I don't know if that's a reason, but and the parents were immigrants, so didn't feel comfortable asking the question why.
Yeah.
Mm-hmm.
Well, I mean, that, first of all, I would say the kid who's being asked to give up the phone, or told to give up the phone, would probably be detained at that point, who would have then the right to call his parents, or her parents, and a lawyer, and that could derail the whole process at that point. If the officer didn't have reasonable, well, first of all, that's a warrantless search,
Yeah.
okay? So if you don't have a search warrant, we should probably, we'll talk about this with warrants, but police officers are not allowed to search and seize unless they have a warrant or unless they're otherwise authorized by law, for example, incidental to an arrest. So it has to be authorized by law. So in this particular, and if it's a search without a warrant, it's presumed to be unreasonable. Or if it's a search without lawful authorization, now lawful authorization can be like breath samples, alcohol breath samples. That is lawfully authorized without a warrant. It's all in the criminal code. So that, this particular search would be warrantless, would be presumed to be unreasonable, which is a breach of the charter and a breach of the police officer's duties. And in that particular case, a police officer can get what's called a tele-warrant. So a justice of the peace is telephone, like if it's an emergency, just phone up a justice of the peace, give your evidence under oath about why you need this warrant to seize these phones, and then a warrant can be issued and electronically communicated to the officer. So obviously this officer, and it's unusual that in this situation you would think that the officer would have had time to get a warrant. So it's a warrantless search, presumed to be unreasonable. Have to give up the password. That's another kind of search. And probably, well, it's a breach of your right to remain silent. Presumably these kids weren't told about their right to counsel or anything. Like, that is like the full meal deal of charter breaches.
Yeah.
Okay? And they weren't charged. They had been charged that because there was something on the phone, it would be highly likely that the evidence would be excluded by the judge, and the Crown probably wouldn't even prosecute it because it's so egregious. Yeah, we'll talk later about making complaints and what you can do about this kind of stuff after it's over. Because cops can get pretty aggressive with bar owners if there's been some problems at your bar. So what this means is that the cop can walk into the bar, and remember what Kate said, it's a private business, and say, you, get out. I'm evicting you. I'm giving you notice under the Petty Trespass Act. You must leave right now. Without even talking to the bar owner, because they don't like that person being in the bar. Yeah, okay, so that covers that, right?
Yeah, there's another thing in bars, or licensed establishments under the Gaming and Liquor Act. There's a section 69.1, and essentially it gives police the power to remove anybody they think is or may be affiliated with a gang. And this section, I think it's unconstitutional. It hasn't been challenged yet, but it's very broad and vague. Basically, any sort of information, any type of information that the police officer has that they personally believe affiliates you with a gang, they can then remove you from the licensed premises. So it could be something as simple as they saw you talking to somebody on the street a couple weeks ago with somebody they know is a gang member. You're affiliated with a gang, so based on that small piece of information, they're ejecting you. It could be something as little and small and vague as that. So I think that's very problematic, but that's the state of the law right now, so keep that in mind.
And again, the idea is you cooperate and complain later because they may well be abusing their authority.
So this deals with vehicle stops. What do you do if you're pulled over by the police when you're driving? So police can conduct traffic stops at random in two scenarios. The first is they want to check your license, registration, and insurance, or check stops. So I think you all probably know what a check stop is. They set up, there's a bunch of police vehicles and they have breath testing equipment on scene, and they can stop you at random to see if they have suspicion that you're impaired by drug or alcohol. When you're stopped by police, you must provide your license, registration, and insurance. And other than that, you don't have any obligation to tell the police anything else. So as always, golden rule, remain silent.
What about when they're doing the check stop and they get your breathalyzer? What about the DNA sample season?
DNA?
Yep. Just rub your mouth?
Oh, yeah, but no, they're not doing that for DNA, they're doing that for drug in your system.
Well, they're taking DNA.
Well, yeah, they're taking DNA, but you know, they could do that with they're allowed to take a blood sample under the criminal code for alcohol testing too.
Well,
They can't
take a cigarette.
They can't, you know, have a DNA analyzed and put it in the DNA bank, for example. If they do that, that would be an illegal search. Go, okay. All right, so, yeah, so you're stopped randomly, license, registration, insurance, or check stop. Officer is not allowed to search your vehicle unless the officer, for example, comes up and sees a handgun laying on the console. So obviously the officer is going to be able to do something about that. But they don't have any grounds generally to search your vehicle and make sure that you don't consent and that you object if they do, but you don't physically resist. I think we've already covered investigative detention, arrest. If they arrest you for trafficking, then, and you're operating a vehicle, then, or you're just outside of the vehicle and they know that you've been in the vehicle, they're going to be allowed to search your vehicle in connection with the arrest, just looking for evidence that might pertain to why you were arrested. And they can do that without a warrant. That's authorized by law. And you're arrested for impaired driving, they can search your vehicle for booze.
Let's say somebody, you know, with this law now with marijuana being legal.
Pardon me?
Was marijuana being legal?
Yeah.
And if you just had it on your dashboard, could they search your whole vehicle if it's legal?
I think that's against the law. I think you can have it, because you can't have it in reach.
Yeah.
The same way you couldn't have like a bottle of alcohol on the
Yeah.
seat beside you. It would have to be in your glove box or
Yeah.
elsewhere.
I'm not up on the new law about that, but I think that's right. Can't be within reach, same as booze, right? So they could seize that. Can they search the whole vehicle? I would say no. What for? It's just for possession of, just for a regulatory offense, right?
Let's say it was in the back part of your car, the window, where they could see it. And
Yeah, but
you can't reach it.
You can't, well, then they shouldn't be allowed to seize it, yeah. And even more, to go through your whole vehicle. Which they do all the time. You know, they look in the trunk and everything like that, but yeah, it's illegal.
What if you're pulled over and the officer asks you to provide a sample of your breath? So first of all, there's two types of samples that you can give. The first is in roadside, so at the road, the breathalyzer, the machine that you blow into. And the second is found either at a check stop or at a police station, and that is a sample that you give to a breath technician, and it's a lot more accurate technology, machinery. There's a technician trained in how to take breath samples, and you usually are at that point if you failed the roadside, and failed means you've blown over point.
Over 100.
Over 100,
Yeah.
right. So at the roadside, the Supreme Court of Canada has found that a person doesn't have a right to speak to a lawyer before deciding whether to comply with a roadside breath demand. So that's important. And when can an officer request a roadside? If they have reasonable suspicion that you consumed drug or alcohol within the last 3 hours, and also that you've driven a motor vehicle or an aircraft or a boat or a plane. So that's what's required. Here's the hard part. When do you decide whether or not you should comply with the breath demand? That's very difficult because you may think that an officer does not have reasonable suspicion. For example, you haven't had anything to drink and they're asking you for a breath sample. That's really difficult because on the one hand, you can refuse. You are legally entitled to refuse if they don't have suspicion, but you will be charged for refusing to provide a breath sample. You'll be suspended from driving for 90 days. After the 90 days is finished, you can't drive without that interlock device in your car. So, Tom, can you talk about how to make that decision about whether you should provide a sample or not? How do you make that decision?
Yeah, so like Kate says, that's a really tough one. I remember I got pulled over in front of the Edmonton Police Headquarters. Had 3 of my kids in the vehicle, and I think I burned a Yui right in front of the cop shop. And so I was stopped, and I was put in the back seat of the police vehicle, and they said, "How much have you had to drink tonight?" And I said, "Nothing," which was true. Then they said, "Well, your eyes look bloodshot," and I said, "Really? I don't think so." And then the cop said, "I'm making a demand for a sample of your breath, a roadside screening." And I said, "Well, that's interesting. What grounds do you think you have for that?" "Well, I have a reasonable suspicion you have alcohol in your body," right? So my decision at that time, even though I would blow nothing, was to comply because I had nothing in my body. And I knew that these cops, if I refused, would charge me, claim that they smelled alcohol and all this stuff, and lie about it, because I could just tell that these were that type of cops. But I'm a defense lawyer, okay? You're dealing with lay people. So my advice would be, if you don't, regardless, if you don't think that they smell alcohol or they observed any signs of impairment, my advice is blow. Because if you fail it and then they use that as grounds for the intoxilizer samples, the 2 samples at the police station or in the check stop van, and you fail that and then you're charged with impaired driving and blowing over 80, your lawyer might look at it and say, well, that first test was illegal. That's an illegal search because they didn't have grounds. That's a breach of Section 8, and there goes the rest of the evidence. So my advice is you always take the roadside sample. It's a tough thing for a person to do, but that's basically the advice. You know, this is a really specialized area. I think there's a threshold of what has to be in your body, but I don't know what it is. And if they don't have that, they're going to have to prove that beyond a reasonable doubt that you're impaired by a drug. So just having it in your system doesn't prove that you're impaired by it, you know. I can't really tell you anything more than that because I'm just not qualified to. The advice I give is, well, even if you're over, blow, but if I get information from my client or the guy who calls me that they had no reason for the roadside screening device, I might advise them that it's in legal demand and they could refuse. It's a real technical area. It's a real sort of a gut judgment. But one you can't make without talking to a lawyer.
So what if you're just a passenger in a vehicle that's pulled over? Passengers are not detained unless you have some reason to believe you are detained. So if you're a passenger and you think something's gonna go down with the police, you can just get out of the car and walk away. That's your right. If the police officer says, hey, you're not free to go, then at that point, you're detained and everything that we talked about applies.
So what do you say? The cop says, I'm not free to go? You're not free to
Why am
go?
I being detained?
Huh? Yeah. Then,
Nothing?
Lawyer.
lawyer. I want to call a lawyer right now, right here.
So if you don't get out of the car and you stay there and police officers come and talk to the driver, there's usually their partner will then come and talk to you. The passenger, they're going to ask you for your name. You do not have to give it, and my advice is do not give it, because the reason they're asking you for their name is they're going to take that information, they're going to go back to their police vehicle, they're going to enter it into their computer to see if you have any warrants, and then they're going to arrest you. So even if you don't have any warrants, even if you have nothing to hide, you don't have to give your name. You don't have to. And if you're not sure if you can go or not, again, am I free to go? The same concepts we discussed apply in this situation.
And if you give your name, it's going to wind up in a police report and your name's going to be in a database.